Chapter 3. The nature of the UK Constitution. The UK Constitution is distinctive in comparison to many other constitutions around the world. It is shaped by history, practice, and evolving legal and political principles rather than a single foundational document. Understanding its nature is essential for interpreting how power operates within the UK legal system. Key features of the UK Constitution. The UK Constitution is not written in a single consolidated document. Instead, it is uncodified, meaning its rules are found across various sources: statute, law, common law conventions, works of authority, international obligations. While there is no single text labelled the Constitution, collectively these sources define how the UK is governed. As famously described by A.V. Dicey, parliamentary sovereignty means that Parliament can make or unmake any law it chooses, and no other body can override or set aside its legislation. This principle is central to the UK Constitution and distinguishes it from countries with entrenched constitutional texts. Rule of law. According to Dicey, the rule of law is a cornerstone of the UK Constitution. It ensures that no one is above the law, legal disputes are resolved by the courts, public authorities act within legal limits. The rule of law provides an essential check on the powers of government, especially in an uncodified system. Constitutional monarchy. The UK is a constitutional monarchy, meaning that the monarch's powers are largely symbolic and limited by constitutional rules. Most powers are exercised on the advice of government ministers. Flexible constitution. Unlike constitutions that require a special process for amendment, for example referendums, supermajorities, the UK Constitution is flexible. It can be changed by ordinary legislation passed by Parliament. This allows the Constitution to evolve over time, but also makes it vulnerable to rapid changes. Political, not legal, constitution. The UK's constitution relies heavily on political controls, such as elections, parliamentary debate and conventions, rather than legal mechanisms. Courts traditionally have limited power to strike down legislation. However, the rise of judicial review, the Human Rights Act 1998, and cases like Miller have begun to shift this balance. Constitutional conventions. These are unwritten rules that guide political behaviour. While not legally enforceable, they are considered binding in practice. Examples include: the monarch must give royal assent to legislation, the Prime Minister must be a member of the House of Commons, ministers are collectively responsible to Parliament. The UK Constitution is uncodified, flexible, and based on both law and convention. Parliamentary sovereignty and the rule of law are core principles. Unlike codified constitutions, the UK system evolves through political and legal developments. The Constitution depends heavily on parliamentary control and political accountability rather than legal entrenchment.